Welcome back and congratulations. You made it to the final video for this course. So let's chat about what we find are the biggest violations of our clients' consumer rights when it comes to the credit bureaus and the collection agencies. So as you're going through the process of disputing all those negative accounts that are unverifiable or inaccurate on your credit reports, you may find times where the credit bureaus have not sent you anything back in the mail yet, or they won't return your results. So this is probably the most common violation that we see. Remember how we constantly, pushed for you to use the certified mail, send everything via certified mail, and that you also need to sign up for informed delivery with the United States Post Office? Well, if you had done so, well, now you have the proof that not only did the Bureau receive your letters, but that they also did not return anything to you as well. So that's going to be your first violation. The second most common violation that we see is when a client has Medicaid or state-provided health insurance, and that's 100% pay, okay? When that happens and you also still end up with a medical collection on your credit reports, that's a big violation. Now you do need to first dispute that account with the credit bureaus, and you do have to give them the chance to fix their records. But if you tell them, and better yet, provide proof, whether you make a Xerox copy of your Medicaid card or you call the state and you get paperwork for that coverage, that's the best way to go about that. And when you send that with your disputes and the account is still not removed, then it's certainly time to get an attorney involved. The third most common violation that we see are those duplicate accounts that we previously discussed. You will need to dispute those as duplicate accounts. Literally write that on your reasoning when you send these template letters. But you're going to do that on your second round of investigation letters as well. When they don't remove those, once again, that's a pretty clear violation. Now, of course, anytime you do find an inaccuracy on your credit reports and you do provide proof of such to the credit bureaus and they still refuse to remove or at least update the account to accurate based on what you've provided them, once again, that's certainly a violation of the Fair Credit Reporting Act. So the question becomes, how does an attorney help you get your desired results of removal of unverifiable or inaccurate information from your credit file? Well, bottom line, they file a lawsuit against the credit bureaus. And what we're going to try and do is attempt to force the deletion or also ask for a monetary settlement to compensate you for violating your rights. By no means will this make you rich, but it'll typically be a few hundred, maybe even a few $1,000s on and this is the important part though, that's on top of any agreed upon deletions in the settlement. And that's what we really want. Always our goal here is to get rid of as many inaccurate and unverifiable accounts. So that's the credit bureaus. Let's move on to those collection companies. So a collection company has been calling you nonstop, and you've instructed them that you only want to be contacted by mail. Now, you've sent them the cease and desist letter that we provided you, and you also sent that by certified mail. Now, after the company has received your letter, and with all certified mail, there's always a tracking number, so you can always check to see if they've actually gotten it, and that's pretty easy. But after they've received this, and they continue to call you, they have now violated your rights. If a company calls you and threatens you with a lawsuit, they threaten you with garnishment, or they even threaten to send the police and arrest you, those are violations. Make sure that you're keeping a log of all phone calls. Also know that it's illegal for them to call you before 9 a.m. or after 9 p.m. If this is a situation that you're in, it's time to contact an attorney. Now, we've included a link on the reference page in this download as well. So if you're ever run into any of these situations and you have a few extra questions, you can always schedule a phone call with us, and we'd be glad to speak with you and help point you in the right direction. Finally, if you have been served with a court summons or civil action has been taken against you by a company in an attempt to collect a debt, please consult a local attorney as soon as possible. If you fail to respond to that summons, there is an excellent chance that a default judgment will be entered against you. And the company seeking to collect, or the one that's are taking you to court essentially, they will now be able to garnish your wages. Please, 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 when you get these court summons, if you ever do, contact a local attorney as soon as possible. Thanks.